First, I want to thank you for coming and allowing me some time to talk with you about this. The American judiciary is in crisis. As a fire hose of falsehoods and a landslide of lawlessness emanates from Washington, D.C. every single day. And that crisis can happen here if we Democrats are not judicious in our choices. Now, what is a retention election? Here's a hint. It's not a choice of laxatives. Okay? In Pennsylvania, judges are elected for a 10-year term. And after that 10 years, voters have a chance to say whether they want to retain a judge on the bench for another 10 years. If voters say yes, that's pretty much the end of it. The judge has another 10 years. If voters say no, it gets a bit more complicated. The judge who is denied retention leaves the bench. And in the case of a Supreme Court justice, the governor appoints a replacement until the next election in an odd-numbered year. And that year, the parties put up candidates and voters decide, just as in any other election. Now, the court has 7 members. Right now, there are 5 Democrats and 2 Republicans. It had been 5 Republicans and 2 Democrats until 10 years ago when voters put 3 Democrats on the court, the 3 who are now up for retention. Justice Christine Donahue, Justice Kevin Dougherty, and Justice David Wecht. This year, if voters deny the retention of just 2 of these 3 justices, Republicans will get the chance in 2027 to take control of our Supreme Court. National MAGA Republican groups see this opportunity very clearly. They already have 23 people on the ground in Pennsylvania, registering their voters and preparing them to turn out. They are going to spend millions, primarily financed by Jeffrey Yass and a couple of other billionaires, on a vote no campaign. And we have to be able to say yes louder. Now, what's at stake in this election? Well, to find out what's at stake, you have to kind of look backwards. And here are a few examples. Without a Democratic majority over the past 10 years, 2.6 million mail-in ballots would have been thrown out in 2020, giving the state and the presidency to Donald Trump. Now, if that's not a good enough reason to vote, and to vote yes this year, here are 5 other cases that prove that a Democratic majority matters. This court threw out the cynically gerrymandered legislative districts that Republicans created after the last census to further their own interests. Sound familiar? Texas, maybe?
Yeah.
Public schools statewide now have an uncontested ruling that they are constitutionally entitled to full and fair funding for every community school. That happened because of Democrats on the court. Over Republican objections, the governor is still able to use the power granted by law during times of emergencies. Without a Democratic majority, victims of medical malpractice would face more hurdles in bringing their cases to court. And this court ruled that the Environmental Rights Amendment to our state constitution cannot be ignored by local governments, which Republicans said should be able to pollute without consequence. It's not hard to guess how a Republican majority would have ruled on these cases. Now I'm going to take the importance of judicial elections a little bit deeper. Many here will remember the infamous pay raise of 2005. Fewer may remember that 2005 was the one and only time in Pennsylvania history that voters denied a sitting Supreme Court justice retention. I was the one who engineered that vote no campaign. And here's why I did it and why it matters now. The campaign actually began in July of 2004, a year before the pay raise, when Pennsylvania became the slot machine capital of the East Coast. The legislature and governor did it without public hearings, over a holiday weekend, and clearly in violation of 3 constitutional rules for how to enact laws. The original purpose rule says that a bill introduced for one purpose cannot be diverted to a different purpose. The single subject rule says that every bill must be considered as one subject. And if you have more than one subject, then you need more than one bill for each subject. And the 3-day rule says that every bill must be considered on 3 different days in the House and 3 different days in the Senate. The entire intent and value of these rules are to give citizens the chance to know what their government is doing in time at least to express an opinion about it before it's too late. So with that in mind, here's how the slots gambling law was enacted. This is the original bill that was introduced. It's a page and a half, and it required background checks at horse racing tracks. The House considered it for 47 days and passed it without amendment. In the Senate, it was considered for 100 days before being amended with this. 146 pages of legislation that had never been seen outside the Capitol. And without public hearings, it passed the Senate, went back to the House, which approved the amended version, and was signed by Governor Ed Rendell in a matter of hours. And this is every word that the 2 bills have in common. These are not words, these are the names of the original co-sponsors of the legislation. In other words, this is every word that actually got 3 days of consideration in the House and 3 days of consideration in the Senate. This is every word of the original purpose that survived the final enactment. And of course, the 146 pages contain several subjects that should have been considered in different bills. But that would have made it far more complicated to deal with in a matter of hours. Most important, and most critically, the amended bill gave our Supreme Court original jurisdiction to decide cases brought against the law. This is highly unusual, but it meant that no lower court could hear those cases and develop a history of arguments that the Supreme Court would have to consider. It also meant that it would take a whole lot longer before a case got to the Supreme Court. Well, the slots gambling law was challenged in court, but despite constitutional violations so clear that even Stevie Wonder could see them, the Supreme Court ruled unanimously on June 22nd, 2005, that this kind of stealth legislation was okay by them. 2 weeks later, the General Assembly and Governor used the identical procedure to pass the pay raise of 2005, which provided the biggest pay raises to, you guessed it, the judges. If you think any of this was coincidental, starting in 2004 and probably before 2004, you are mistaken. And we can talk about that later if you want. The corruption and conspiracy between the Supreme Court, the General Assembly, and the governor are the reason I mounted the Vote No campaign. That year was the first opportunity voters had to stop the villainy. Only 2 justices were up for retention that year, and in November, the voters decided not to retain Justice Russell Nigro and almost decided not to retain Sandra Schultz Newman. I put that in, made that banner in my basement the night before a rally at the Capitol. A historic artifact from 20 years ago. But the bottom line of this story is simple. How things get done determines what things get done. If the Supreme Court hadn't told lawmakers that they could ignore the Constitution, lawmakers couldn't have done the pay raise the way they did it. And probably couldn't have done it at all because there would have been an aroused populace with pitchforks and torches telling them not to do it. To preserve our rights, we need the courts, all of them, to enforce the Constitution's instructions for how we get things done. It's clear from the assault on courts engineered by Republicans in Washington that only Democrats will defend the rule of law. without which there is no democracy worthy of the name. If we want the right to vote by mail, legislative districts that treat voters fairly, fully funded schools to serve every child in every community, the governor to respond to emergencies without political interference, the right to a day in court if you suffer medical malpractice, and an environmental rights amendment whose plain language can be enforced. We simply must vote this year. Confronted by a Republican Party that only knows how to say no to democracy and individual rights, we Democrats have abundant reasons to say yes to Justice Christine Donahue, yes to Justice Kevin Dougherty, and yes to Justice David Webb. Let's make sure we do it.
Yeah.